And the next item of business is debate on motion 23014 in the name of Christine Graham on the final stage of the Solicitors and the Supreme Courts of Scotland Amendment Bill. Before the debate begins, the presiding officer is required under standing orders to decide whether, in his view, any provision of the bill relates to a protected subject matter. That is, whether it modifies the electoral system and franchise for Scottish Parliament elections. In the case of this bill, he has decided that no provision relates to a protected subject matter. Therefore, the bill does not require a supermajority to be passed at stage 3. Can I invite members who wish to speak in this debate to press the request to speak buttons? And I call on Christine Graham to speak to and move the motion on behalf of the committee for up to 5 minutes. Please, Ms Graham.
Thank you very much, Presiding Officer. I'm pleased to open the final stage debate on the Solicitors and the Supreme Courts of Scotland Amendment Bill. I thank my colleagues on the Private Bill Committee, Bill Bowman, the Deputy Convener, Daniel Johnson and John Mason for their work in the committee. The bill was introduced on 26 September 2019 and is being promoted by the Society of Solicitors in the Supreme Courts of Scotland, known as the SSC Society. The bill passed preliminary stage on 19 August 2020 and completed consideration stage on 7 September 2020. If the Parliament passes the bill today, it will give the Society powers to wind itself up, create new types of membership, allow members of the Society to resign, abolish the offices of Librarian and Fiscal, rename the Widows Fund as the Dependents Fund, and give the Society powers to close that fund to new members or to close it completely. As members will recall from the preliminary stage debate, the benefits of membership of the Society today include access to the Society's building at Parliament House in Edinburgh and use of a legal library and members' lounge, and membership of the Widows Fund, renamed the Dependents Fund by the bill. The Society currently has around 220 members spread throughout Scotland and is run by 5 office bearers and a council of 6 members. Over recent years, demographic changes within the membership have meant that the Society now finds itself with a predominantly older retired membership, with fewer younger members joining. This is not unusual for these types of societies nowadays. There is therefore a concern that a dwindling number of members may find themselves one day in the position where the Society or Dependents Fund needs to be wound up, but without the powers to do so. One of the objectives of the bill is therefore also to enable the Society to attract new members, creating different forms of membership. For example, corporate membership, trainee membership and associate membership. This will, it is hoped, encourage younger members of the legal profession to join the Society. New members will also be able to make use of the library and facilities at the Society's building in Parliament Square when it's possible to do so, though not under the current circumstances. At preliminary stage, the committee questioned whether there would be the possibility of a sudden influx of corporate or associate members who might then disagree with a decision taken by the small group of remaining full Society members. The promoter explained that it would be clear from the outset, and indeed in the bill, that these new types of members would not have voting rights. The bill also contains a provision which will give members the ability to resign their membership, unconnected from any disciplinary matters or retirement. At present, if a member fails to pay their membership fees for 2 years, their membership automatically ceases. However, we heard from the promoter that this is an unwieldy process and that allowing members to resign their membership would be useful. Part of the committee's role has been to assess whether the bill will actually achieve these objectives. The committee undertook a thorough examination of the bill at preliminary stage. We considered the purpose of the bill and whether it would give the Society the powers that it required. We also considered whether the bill should proceed as a private bill. One of the interesting aspects of being involved with this bill has been gaining an understanding how private bills differ from the public bills that are scrutinised by this Parliament. With a private bill, the committee is also required to satisfy itself on 2 points: that the bill conforms to the definition of a private bill as set out in the standing orders, and that the accompanying documents conform to the Parliament's standing orders and are adequate to allow proper scrutiny of the bill. On 17 December 2019, the committee therefore held an evidence session with the Society's office bearers and their drafting advisor. During the committee's evidence session with the promoter, the office bearers emphasised from the outset that they are not expecting to wind up the fund or the society anytime soon. However, they wish to have the mechanisms in place in case they are required in the future, so that the winding up can proceed in an orderly fashion. Understandably, the current office bearers wish to avoid leaving members with the prospect of having to raise an urgent action before the Court of Session. The committee also asked how the winding up of the assets would work and questioned whether the procedures for closing the newly named Dependents Fund and winding up the society were robust enough. My committee colleagues will provide more detail on the amendments made at consideration stage that strengthened the bill. The committee's preliminary stage report, published on 15 January 2020, covers our questions and recommendations about the bill in some detail, reflected in the preliminary stage debate held on 19th August. The bill passed preliminary stage when the Parliament agreed with the committee's recommendation to agree the general principles of the bill and that the bill should proceed as a private bill. As no objections were lodged in the initial 60-day objection period, at consideration stage the committee turned straight to the amendments. I lodged 11 amendments on the promoter's behalf, which all addressed the committee's recommendations in the preliminary stage report. My committee colleagues will touch on other aspects of our work on the bill, including the consideration stage amendments. I will conclude by stating the committee recommends that the Scottish Parliament agree that the bill be passed. I therefore move that the Parliament agrees that the Solicitors in the Supreme Courts of Scotland Amendment Bill be passed. Thank you.
I now call Daniel Johnson for up to 4 minutes, please.
Thank you very much, Deputy Presiding Officer. I too would like to thank my colleagues for their work on this bill to this stage. But I'd also like to add my thanks to the clerks. And I'm going to very slightly depart from my script here, but just briefly, because the work that is carried out on private bills is incredibly important and an important duty that we have in this Parliament, but one that is by its very nature niche, but obviously of fundamental importance to organisations such as the Solicitors of the Supreme Court, whose functions and underpinnings are set out in statute. So I thank the clerks for keeping us straight and for keeping on top of the detail and for getting this bill through to this stage. For my contribution, I intend to concentrate on the mechanisms required in the winding up of the society and in certain aspects of the society's meetings. The promoter made it clear from the outset that the main aim of the bill is to address the lack of powers in the 1871 Act to wind up the society. It came to the attention of the current office bearers that should the society one day find itself in the regrettable position of having to be wound up, the society currently lacks the powers to do so. It is understandable that the office bearers do not wish to find themselves, as one office bearer put it, aged 85 and the only person left at the table, only able to resign from office, walk away and leave an organisation that still exists with nobody to manage it. Quite so. The bill therefore inserts a new section, 52B, into the 1871 Act. This new section sets out the general process for decisions on winding up of the society. The process starts with the Council agreeing a proposal to wind up the society, followed by either a general meeting of the members or bylaws being made to decide the procedures to be followed at a special general meeting. The Society's members must be given at least 30 days' notice of the special general meeting, at which they will then consider the proposal to wind up the Society using the previously agreed on procedure. If the members vote to wind up the Society, the Council will then implement this decision, either in accordance with the arrangements made by the Society or in such manner as the Council considers expedient. At preliminary stage, the committee questioned whether the procedure to dispose of the Society's assets was detailed and robust enough to encompass any tensions as a result of the division of the Society's substantial assets. We noted that even with the best of intentions, the division of assets may lead to tensions. It was therefore welcome that the promoter proposed amendments to the bill at consideration stage to strengthen the procedure around the division of the Society's assets, which include the Society's headquarters situated just off the Royal Mile. The bill has therefore now been amended to require that the Society's members are consulted as to how any property be distributed in the event of the Society being wound up. This consultation must take place before the special general meeting, where members would discuss any proposal to wind up the Society. Presiding Officer, I hope that I have provided members with useful detail on how the bill has been amended at consideration stage to strengthen the procedures for winding up the society. However, as the promoter has made clear throughout the passage of the bill, it is hoped that these procedures will not be required anytime soon. I agree with the committee's recommendation that the Scottish Parliament agrees to this bill being passed. Thank you very much.
We have one open debate speaker, and that's John Mason for up to 4 minutes, please.
Thank you very much, Presiding Officer. I too thank my colleagues on the committee for their work on this bill to this stage, also to the clerks, the promoter, and I thank the convener, Christine Graham, for moving the motion and her professional way of chairing the committee. As the convener mentioned, the bill is necessary as the promoter has noted the changing demographics within the society. The office bearers are currently faced with an ageing membership, which may result in their one day having to wind the society up. The committee therefore agrees with the promoter that it is necessary to ensure that should that unfortunate circumstance take place, the society has the powers that it requires to allow for an orderly closure of the society, the Dependants Fund, or both. The Solicitors in the Supreme Courts of Scotland Act 1871 set out the procedures governing the Society's Widows Fund. The bill has renamed that fund the Dependants Fund and has inserted new detailed procedures that would allow for it to be closed to new members or closed completely. These procedures include an actuarial investigation, a meeting of the members to consider a resolution to close the fund, and the offer of, quote, such lump sum or other payment as seems reasonable, unquote, for the annuitants and potential future annuitants. Any residual money would then transfer to the society. Whilst the committee generally agreed with these provisions, we noted that the promoter might want to consider, as part of the winding up procedures, a provision in the bill that the beneficiaries and any prospective beneficiaries should be notified of a proposal to close the fund. The promoter has accepted this recommendation, and amendments were lodged at consideration stage to address this. These amendments mean that the bill now requires that all annuitants and prospective annuitants be notified in advance of any decision to close the Dependants Fund completely. The committee also examined the procedures involved in winding up the society. Our intention was to ensure that the procedures were as robust as possible and that the promoter would not find itself in the position of having to come back to Parliament again to amend the 1871 Act. Whilst we agree that it is the right of the Society's members to make their own decisions about its future, we did consider that some of the practical procedures around decision-making could be strengthened. At preliminary stage, the committee heard that only around 10 of the current 220 members attend the Society's statutory general meetings. We noted our concerns about the lack of requirement in the bill for a quorum in the decision-making process, and that a voting threshold was not mandatory for meetings where winding-up decisions were to be taken. The committee therefore welcomed the promoter's proposed amendments to ensure that for any decision to wind up the society, a voting threshold must be set, which the bill now requires. Presiding Officer, it has been interesting to experience the private bill process and to play a slightly different role to the usual one of a committee member. Generally speaking, I enjoy a bit of controversy, and there really has been none of that in this bill. However, it has been interesting nonetheless. I agree with the committee's recommendation that the Scottish Parliament agrees that the bill be passed. Thank you.
Can I now call Bill Bowman, please, to wind up the debate on behalf of the committee for up to 5 minutes, please.
Thank you, Deputy Presiding Officer. In closing, on behalf of the committee, I too thank my colleagues for their work on the bill so far, and I would also like to again thank the Society's Secretary, Robert Shields, for showing us around the Society's building at Parliament Square. It was a useful visit and helped to set the context for the position that the Society, which has an entirely voluntary membership, now finds itself in. The Solicitors in the Supreme Courts of Scotland Act 1871 forms the statutory constitution for the Society. However, one omission in the Act was any powers for the Society to wind itself up, either because the then members did not foresee a day when the Society may not exist, or because they deliberately did not include any powers that would allow the Society to close down. In 79, elements of the 1871 Act were amended to reflect the changes that had occurred over the previous century, but did not address the issue of the lack of powers. As my colleagues have mentioned, the Society's office bearers were clear from the outset that there is no wish to close either the Dependents Fund or the Society itself in the near future. However, the office bearers have acted prudently by ensuring that, should the bill be passed today, the Society's constitution will now set out the necessary powers to allow it to be wound up. In the bill's accompanying documents and in the evidence to the committee, the promoter set out a number of alternatives that were considered instead of primary legislation. The policy memorandum notes that under the common law, the doctrine of si pre would allow the trustees to make an application to the Court of Session to have the terms of a public trust varied where the purposes of the trust are or have become impossible to fulfil or have become particularly inappropriate. However, due to the nature of the Dependents Fund, any attempt by the trustees to close the fund or vary the payment of entitlement to lump sums against future entitlements means that, according to the promoters, a si pre scheme is very unlikely to be approved by the court. The promoter also noted that Section 9 of the Law Reform Miscellaneous Provision Scotland Act 1990 gives the Sheriff Court and the Court of Session powers to approve a scheme for the variation or reorganisation of the trust purposes in any public trust. However, as with the si pre scheme, the trustees believed this to be unsuitable for the Dependents Fund. The trustees also considered sections 39 and 40 of the Charities and Trustees Investment Scotland Act 2005 as a means of providing the required powers, and considered that, as the use of the fund cannot be said to be dedicated to a charitable purpose, such it would not seem to qualify under this Act. The bill therefore seeks to modernise the Society's statutory constitution, that is the 1871 Act, and its purposes include giving the Society powers to wind itself up in the future, creating new types of memberships and making new provision to allow members of the Society to resign, and abolishing the offices of librarian and fiscal. One of the other objectives of the bill is to update some aspects of the Act's terminology. Widows Fund is being changed to Dependents Fund, and references to lawful children is being removed. The bill will allow the trustees to pay annuity claims based on cohabitation, depending on the facts and circumstances between the deceased member and the claimant. And as I noted at the preliminary stage, the promoter is also removing the offices of librarian and fiscal. The role of fiscal was a historic office for handling matters of discipline, which is now dealt with by the Law Society of Scotland and the Scottish Legal Complaints Commission. The office of librarian is being removed as, although the Society will still have a librarian, that person is no longer required to be a qualified solicitor. As my colleagues have noted, 11 amendments were lodged on behalf of the promoter at consideration stage. These amendments improve the bill and strengthen the procedures surrounding the winding up of the Society and the Dependents Fund. I'm grateful to the promoter for taking on board our recommendation in the preliminary stage report. The amendments not yet mentioned by my colleagues include minor and technical amendments, for example, ensuring that the 1871 Act is consistent in terms of style. One amendment also clarified the type of meeting a member created under one of the new forms of membership set out in the bill would not be entitled to participate in. Deputy Presiding Officer, this bill has been fascinating to work on, not least because it has meant the committee has played a small part in a society that has been in existence for over 2 centuries. When the Society was formed in 1784 and made a body corporate through a Royal Charter granted in 1797, I doubt that the founding members could have envisaged their society being debated in the Scottish Parliament over 200 years later. Perhaps we might think of 2220 as to what might be happening here. The setting up of the Widows Fund, now Dependents Fund, in 1817 also means that annuities have been paid to surviving spouses and orphans of the Society's members for over 200 years. Deputy Presiding Officer, I agree with the committee's recommendation that the Scottish Parliament agrees that the bill be passed. Thank you.
Thank you, Mr Bowman. Can I just confirm for everyone that Mr Bowman didn't speak for nearly 9 minutes? I forgot to restart the clock. So he was very succinct, and thank you for that. And that concludes the final stage debate on the Solicitors and the Supreme Courts of Scotland Amendment Bill. And it's now time to move on to the next item of business.